When we lawyers talk about employment liability claims, what we really mean is accidents at work. The important thing to understand about bringing an employment liability claim, that is a claim against your employer, is that these days the law imposes such a strong duty of care upon the employer that virtually any accident can be argued to be caused as a result of that breach. They're obliged to provide you with a safe system of work, a safe place of work, whatever personal protective equipment is required. They're basically obliged to ensure that accidents don't happen. And if an accident does happen, it's usually, in some sense or some measure, their fault, and therefore you are entitled to compensation. The breach of duty applies even where you feel, and in many cases where you were, actually partly to blame. Being partly to blame doesn't mean that you can't make a claim at all. It just means that in some circumstances the court may reduce that amount of claim so as to reflect your culpability. So if you've had an accident at work, just give us a call. We'll be able to explain whether you have the basis of a claim, and we'll give you some rough idea as to how much it's worth. We can't give you any specific figures until we've got proper medical evidence, but we'll at least be able to explain how the system works and to deal with any queries or any anxieties that you may have.
Choose the one